Hello, it's Lucy Whitaker here from Pragma Law, driving offence solicitors. At the moment, I'm getting so many calls from people who think they may have received a late notice of intended prosecution or NIP. And so I've made this video to try and give a bit more information because I'm struggling to keep on top of these calls. As I'm sure you'll appreciate, I can't give free advice to everyone with their individual circumstances, so hopefully this will help answer some questions. The NIP, Notice of Intended Prosecution, has to be served within 14 days for certain offences in certain circumstances. If this is not done, then there can be no conviction for the offence to which it relates. So this means that if, for example, a notice of intended prosecution is required for a speeding offence and it's not served within 14 days, then there can be no conviction for speeding. First of all, you need to be sure that the notice of intended prosecution is actually required for the offence that you're dealing with. It is not required for offences of using a mobile phone or driving without insurance or while disqualified. There is a list of the offences on my website, but you need to check that first, because if it doesn't require one, it doesn't matter whether it's served late or not at all, because it's not a requirement. The other thing to note is that it's not required in certain circumstances, so that if the police pulled you over at the time and warned you that you were being reported for consideration of prosecution for that offence, then they're not required to send a notice of intended prosecution on you within 14 days. Neither are they required to if there's been an accident. The notice will be served on the registered keeper at the last known address, which means whatever is on the V5C logbook. So my first bit of advice is to check before you do anything else that you have the logbook and that it's got the correct name and correct address on it, because if you've moved house, for example, and not updated it, then the police are going to be sending the notice to an old address. It's not enough to update your driving licence or just your insurance documents. They're going to be looking at the logbook first of all. Sometimes they will have a look at the insurance documents if they don't get a response, but the legal requirement for the police is to serve it on the registered keeper. So that's what they're going to look at. And if you've forgotten to update your details on the logbook, then that's not going to provide you with a defence to failing to give driver details, and it's not going to mean that the notice has not been served correctly. The other reason it can cause, the other reasons that delays can be caused is if you've recently purchased a vehicle or moved address, or there's been some other change of details with DVLA. Now, whilst DVLA have an online facility to change some details that can be done quite quickly, others take some time. So if you don't know when changes have been made, and it could affect the details that the police are given when they're sending the notice, you need to contact DVLA and find out when the correct details were put on the system. Because the police, although they have to serve the notice within 14 days, they are allowed to serve it outside that time if they could not, with reasonable diligence, have served it on the registered keeper at the last known address. So they're going to get their details from DVLA, and if it's DVLA's fault or there's been some delay in communication, the notice can still be properly served outside the 14-day time limit, even as long as the police are not at fault, essentially, and have acted properly. Notices of intended prosecution are normally or often printed on the same piece of paper as a request for driver details, and these are not the same thing. A request for driver details is exactly what it says. it's a requirement for the recipient to provide details of the driver. The fact that an NIP may have been served late does not mean that you can ignore a notice or that you don't have to give accurate details and when you receive the notice. So please do not think you can ignore something just because it appears to have been sent to you late. You cannot. They could still prosecute you for failing to give driver details, even if they couldn't prosecute you for the original offence of speeding. The 14-day rule applies to when the notice is deemed served. Now, there's a lot of case law on this, and I'm not going to go into too much detail here, but just to explain, the 14 days itself takes into account every day, whether that be a weekend or a bank holiday. It's just 14 days from the date of the offence. However, when we're talking about when it is deemed served from the point of posting, then we do have to take into account bank holidays and weekends. That's quite difficult to explain, so I'm not going to do that here. However, there's a lot of people at the moment receiving notices late because of the strikes. That does not mean that the police don't have to serve the notice within 14 days just because the strike's on. They then should really be using another method to make sure that the notice gets there within time. However, they're not. They're sending them still by first-class post in most cases. When a notice appears to have been posted so that it would be served within time, but it's been stuck in the post, it's very difficult to establish that you haven't received the notice within the 14 days. There's no method of tracking the ordinary first-class post, so it's really your word that the court has to consider when deciding whether or not it's been served in time. So bear in mind that whilst you can write to the police and point out, point out that it was received very late and therefore has not been served within time, they may not accept it and may simply say that you can challenge it in court and have a trial if you want to. And sometimes that's the only way to establish a defence, if on the face of it the notice has been posted so that it would normally be received within 14 days but hasn't been. So just bear that in mind if you are in a position where you may be eligible for a course or a fixed penalty, because if you decline those to challenge it in court, there is the risk, if you are convicted, that you will end up in a worse position than if you accepted the course or the fixed penalty. If you receive a late notice of intended prosecution and you want to challenge it, then I suggest in the first instance that you write to the police and point this out. But at the same time, you must identify the driver if you've received a request to do so. If you would like us to write the letter for you, then would be happy to do that, but we do charge a fee for doing that. We can't provide a free service in that regard. We're just getting so many inquiries at the moment. I hope this video has been informative and provide you with some more information and gets rid of some of the rumours and myths around NIPs, and that it helps you to avoid making some of the mistakes that result from reading incorrect legal information, because there is a lot of it out there. Thank you for watching.